Welcome to everybody, and B'shus Bleich, with Willig, with Rosenzweig. Wow, we have Mamish, an unbelievable collection of Gedolei Rabbanim with us today, and Talmidim from both the Kollel Elyon and the Kollel LHoraah. It's a tremendous honor to be able to address everybody together. Really, all that I wanted to do today was to give a general hakdama to some of the major klolim of Ribbis that are going to be discussed throughout the year. Obviously, they'll be learned in maybe different ways with a different emphasis. The Kollel LHoraah will be focusing more, I would assume, upon halacha l'maaseh, and the Kollel Elyon will be focusing more, I would assume, upon the lamdus. But obviously, there's a connection. Halacha l'maaseh stems from the lamdus. The highest level of learning is asukei shmaitis aliba dehilchasa. So we'll figure out how to put it all together. There are a number of recent sefarim in Hilchos Ribbis that have been published. Really, the Bris Yehuda by Rav Yaakov Yishaya Blau was the first of the contemporary sefarim that paved the way for a contemporary analysis, what you might call a restatement of Hilchos Ribbis from what was found in the Shulchan Aruch. And after the Bris Yehuda came really a tremendous outpouring of additional Sfarim. So even though often they disagree with some of the conclusions of the Bris Yehuda, but he really was the standard bearer in terms of the discussion of Hilchos Ribbis. One of the best Sfarim in terms of just going through the Shulchan Aruch and understanding what in the world is going on is the Chelkas Binyamin, who really explains in great detail every single line of the Mechaber and the Ramah, where everything is coming from. It's a fantastic sefer. And some of the more recent collections that I brought with me today are the Bris Pinchas of Pinchas Wind, who's a contemporary mumcha in Hilchos Ribbis, and he updates this every couple of years. So there's an addition from Tafshin Pei Beis, which is good because this way you're up to date with respect to whatever are the accepted contemporary conclusions regarding all of the major modern day shilas. And you have the Mishpat Ribbis from Rav Aaron Wieder, who also does a very good job at collecting a number of the contemporary shilos and Hilchos Ribbis. Some of the Sfarim that were published 30 years ago or so, including Rabbi Reisman's book, which is also in English language, excellent collection of the laws of Ribbis, are sometimes a little bit out of date in terms of keeping up with the modern day financial transactions, because modern day financial structures have changed a lot over the years. Just like when I started out in the professional world, so most of the communications that were sent out were by fax. And nowadays, you mentioned fax, it's like you're talking about something from the Dark Ages, from when people used to live in caves. They would send things by faxes. So there are a lot of chapters that are devoted to, in many of the Hilchos Ribbis books, to payments by check. So we do still have such an institution as check, but the frequency in which people pay by check is something that, particularly for the younger generation, not as familiar as it once was. People now pay by PayPal, and they pay by Zelle, and there are different also types of financial instruments that didn't exist, like Bitcoins and things like that. So I think it's important as we learn Hilchos Ribbis to really focus on a lot of the contemporary financial structures that might have changed over the years, because they also will have ramifications in terms of whether a particular transaction is d'oraisa, d'rabbanan, and exactly how things are going to be treated from the standpoint of Hilchos Ribbis. So I'll start off. Point number one is a kind of like a low-hanging fruit sort of question. Why is Hilchos Ribbis found in Yoreh De'ah? So there's a right answer, and then there are, some creative answers. But the right answer is the one that's given by the Torah. The Torah explains that it's in Siman. It starts off in Siman Kuf Nun Tes, following on the heels of Siman Kuf Nun Ches, which is the conclusion of a lengthy discussion of Hilchos Avodah Zarah and all of the different applications of things that are relevant to Bisman Hazeh, Yayin Nesach, other things when it comes to relations with the non-Jews, Avodah Zarah, etc. And Siman Kuf Nun Ches in particular speaks about the Chiyuv Hatzala, speaks about who you're supposed to save and in what fashion you're supposed to save people. And there are distinctions that are drawn between if you're dealing with fellow Jews or if you're dealing with idolaters. And for that matter, a distinction is drawn if you're dealing with Jews who are more in the category of idolaters in terms of the way that they conduct themselves. Either they're apikorsim, they're mumrim, so there are variations when it comes to those dinim of whether or not there's a chiyuv hatzalah. So too, there are variations that are discussed in Siman Kuf Tes. When it comes to one of the cornerstones and pillars of Hilchos Ribbis is that you're supposed to see to it that your fellow Jew is able to live and they're able to survive and subsist, and that they're not going to be squeezed out of existence by having to pay interest payments on loans. So that's the idea of imach. And that principle, says the Shulchan Aruch, is only applicable to achicha. It's only applicable to fellow Jews. And even with respect to fellow Jews, it may not be applicable to apikorsim, to mumrim. So we draw these distinctions. That's what this is discussed in Siman Kuf Tes. I think that Rabbi Willigov may have touched upon some of those in Yonim in the first Chaburah of the year. So since that is sort of a continuation on some level of the chiyuv of hatzalah, of giving people chayim, that's in Siman Kuf Tes, so that's discussed in Siman Kuf Tes. And then the Torah says, Ribbis nema be milsa. That since Ribbis is something that has fallen into our laps, because we have to, because while we're on the subject of chiyuv hatzalah and keeping people alive, so Siman Kuf Tes discuss the distinctions when it comes to who you're allowed to charge ribbis to, who you're not allowed to charge ribbis to in terms of providing chiyus, that you're allowed to charge ribbis to non-Jews and to mumrim, but you're not allowed to charge Jews interest to Jews. So therefore, nema be milsa. Therefore, let's continue in our discussion of Hilchos Ribbis. So in other words, it's like minyan linyan, that since it happened to fall into our lap, says the Torah, v'asalon, so we're going to continue in the discussion regarding Hilchos Ribbis. In fact, the Rambam didn't have this restriction. He didn't have sort of a running stream of consciousness, so to speak, regarding Chiyuv Hatzalah. So he more logically places Hilchos Ribbis and Hilchos Malbeh below there, which is where you would figure that it would belong, and where it is located for the purposes of Talmud Bavli. It's located not in Maseches Avodah Zarah. It's located in Maseches Bava Metzia, which is very much Dinei Mamonos. So the other explanation that you can give is that maybe it's serendipitous, that it's true. This is probably the real reason. The real reason why Ribbis is in Yoreh De'ah is because of the fact that it just happened to be a continuation of a discussion regarding the difference between Jews and non-Jews. So once we discussed it in the context of who you can charge Ribbis to, so therefore we're going to discuss the rest of Hilchos Ribbis. But you can say serendipitously this occurred because there is some characteristic of Ribbis that belongs very specifically in Yoreh De'ah, which is that it's Isser v'Heter. The much of Dinei Mamonos is really more in the realm of Choshen Mishpat, insofar as when it comes to Dinei Mamonos, we have a principle that called Tanai Sheba Mamon Kayim. And when it comes to Dinei Mamonos, generally speaking, the two parties to a transaction are not 100% bound to whatever the Torah's laws are. They're allowed to contract around the Torah's laws, like the Mishnah Bava Metzia, Daf Tzadi Daled says that you can have, for example, a shoel that will take who's normally Chaya Ba'onsin, and there'll be a deal that the shoel has with the person who lends him the goods, that this shoel is not going to be a Chaya Ba'onsin. I can have a shoel Mechinam who is normally a potter when it comes to a Gneva Ba'aveda, and they can make a deal that the shoel Mechinam will be Chaya B'Gneva Ba'aveda. Shoel Misacher, who is Chaya B'Gneva Ba'aveda, they can make a deal that'll be potter B'Gneva Ba'aveda. So you can have all kinds of different special side deals that are made when it comes to Dinei Mamonos, because Paskin like Rabbi Yehuda against Rabbi Meir, the Kol Tanai Sheba Mamon Kayim. But when it comes to ritual matters, we don't say Kol Tanai Sheba Isser Kayim. When it comes to ritual matters, you can't make a Tanai that we're going to work on Shabbos. You can't make a Tanai that we're going to eat treif, that we're going to eat chazir. Such a Tanai is considered to be batul and mabutul. So too, when it comes to Hilchos Ribbis, we don't say that it would be permissible for the lover to be moichel at initio, at the very outset of the transaction, to say, oh, it's okay. I know that the Torah gives me the right not to be charged interest, but I'm meichel that it's okay in this particular case that the Malva can charge me interest. That's different from saying down the road, after the Lova has already paid the interest, he could be meichel that the Malva can keep the interest. Okay. But in terms of the transaction getting off the ground, there's no mechila. The Yisr is going to is going to take place, and therefore this is more of a Yoredea Inyan because it doesn't subject itself to Tanai. Not only that, but it's also something where the actual contracting of having a Ribbis transaction itself creates an Isser. It's not necessarily a Dava Pashut. It depends how you read the Sugi at the beginning of Parak Ezu Neshach. What exactly, who do we paskin like? Between the Tanakama on the one hand, Rabbi Chaim, Rabbi Yosef, and Yaakov on the other hand, is whether we say Shulman Milsahi. The Ras Hason is of the opinion, we paskin like the Tanakama, that Shulman Milsahi. That's how most of the post-game seem to assume halacha l'maisa, the Bach and Meyoshe, they assume that there would be a prohibition of losa simun alav neshech. The prohibition that's mentioned in Parshas Mishpatim would take place immediately at the very outset of the transaction. So if you simply put a clause in a promissory note that says that the lover is going to pay interest to the malveh, even if the malveh doesn't really intend on ultimately collecting, just wants to have it as security, just wants to place some sort of a fear in the heart of the lover, that the lover should know that there is this possibility of having to pay extra. Nonetheless, there still is a violation from the very outset of the transaction of losa simun alav neshech, that even if there is simply a contractual clause that the parties sign, that the Ribbis is going to get paid, or they just agree between themselves verbally that the Ribbis is going to get paid. So that already would be a violation of losa simun alav neshech. This is not true with respect to certain other violations, even if they might be ritual prohibitions. There's a question mark. I'm not sure if everybody is in agreement. I know that not everybody is in agreement regarding this issue, but this sometimes comes up with respect to the issue of going to secular courts. So that also is not something that you're allowed to make a Tanai about, in the sense that the Tanai is not going to be Kayim. If two parties to a transaction sign a contract and they say that in the event of a dispute, we agree that we're going to go to the secular courts in the state of New York. So is that something that would have to be respected? So the Shulchan Aruch and Siman Chav Vav paskins that of course that's not something which can be respected, because that's not a Tanai Shebemamon. That's a Tanai. It's also considered to be a Tanai Shebe'isr. But let's say that you want very much to enter into a contract. You have an employment contract and you really need the job very desperately, and the employer is a non-from Jew, and the employer has you sign the contract and says that I'm not going to give you the job unless you sign the contract on which there's a clause, a choice of forum provision that says that in the event that there's a dispute between the parties, it's going to be adjudicated in the courts of the state of New York. So are you allowed to enter into that employment contract? You have to say, no, it's also be an Isser Arkos for me to sign such a clause. So Api Pasha is not an Isser Arkos to sign such a clause. It's Usser to actually go to the Arkos, but to sign a clause where you have you don't want to go to the Arkos. Lemaise, let's say you wanted to go to Bezdin and the other party would refuse to go to Bezdin. So then Bezdin is going to give you a Heter Arkos anyway. Under those circumstances, if the other party refuses to go to Bezdin, so you do have the right to go to court. So the Maharshal in the Yam Shel Shlomo says that in such a case, if you have such a clause, so actually, really, the other party should have agreed to go to Bezdin. But if you see the other party is such a strong-armed anti-halacha individual that they're going to refuse to go to Bezdin, so you can enter into the contract, and then you actually have one advantage of because you enter into this contract, because you know that this is a person who feels so strongly about never going to Bezdin, it's only going to go to Arkos. And normally, if you would have a dispute, you would have to first summon the other person to Bezdin, and only after you get a Heter Arkos would you be allowed to go to court. But in this particular case, since you know that the person insisted on putting into the contract that they're only going to go to court and they're not going to go to Bezdin, so you can assume right away that you have a built-in Heter Arkos. Really, it's the wrong thing, but you're not the one doing the wrong things. The other person is doing the wrong thing. So you, Al Pi Pashtus, the simple reading of the Maharshal, even though the case that he was dealing with was Bain Medina Yisrael, Bain Medina Yakum. It had a sort of a Bain type of clause, but the simple reading of the Marshal and the Yam Shel Shlomo is that there wouldn't be an Isser per se of starting such a contract. That itself would not constitute an Isser or Kos. It's also the other person's prepared to go to Bezdin, so it's also to take them to our Kos. But if the other person refused to go to Bezdin, it's a different story. But here, the Mamish would be an Isser of signing such a contract. Yes, Mordechai.
You're saying we shouldn't sign the Yeshiva contracts that all have the clause that are going to go to the civil courts of the city of New York.
The yeshiva has such a contract. So I said it's not. So I said it's not an Isser Kos. If you know that you're dealing with a party that's such a Rosh, that they would absolutely refuse to ever go to Bezdin. They insist on putting this in the contract. So Al Pi Pashtus, it wouldn't be an Isser, but they would. But they're not allowed. They're not allowed to put they can't put that into such a contract. But that's their issue. That's not your issue. Presumably they don't have that. You're just saying Lu Yitzuya there would be such a thing. No, I'm not Makabel. Of course not. Of course not.
I usually write on the contract. I don't accept that clause.
No, I'm sure they don't have such a clause. It's a mistake. If there is, so maybe they got it from some sort of a form. You have to point it out to the general counsel's office, and they'll correct it. It's impossible. It's impossible. They wouldn't be allowed to. They wouldn't be allowed to. Moshe Feinstein says that if you're the menalim of a Jewish organization, so it's so you don't have authority. You don't have authority as menalim of an organization to put in anything which is anti-halacha. You can't put in a clause which is anti. So that would be batal b'butal. They wouldn't be allowed to do such a thing. To tell the board of directors wouldn't allow it. They just can't. Yeah. Okay, it's impossible. Impossible. Okay, so then the question arises along these lines. Let's say that you have a child that wants to borrow a lot of money from a parent in order to buy a house. This happens all the time. So they need $100,000 loan from a parent or from a good friend. But usually it'll be like a parent, a close relative. Who else is going to make that type of a financial commitment? And the parent, of course, is happy to do it as an interest-free loan. The thing is that if you make it as an interest-free loan, so then the government is going to impute interest income. They're going to say that there's no such thing as an interest-free loan. What? It can't be. There's a certain amount of interest income that's not being reported over here, and therefore we're going to impute that income and we're going to charge tax on it. So in order to avoid having the tax charged, so the parties just put in to the contract that there's a de minimis type of interest rate. We know that pi halacha, any kind of interest is also. Shulchan Aruch paskins, you can't even charge a pachas v'sharaputa. So whether it be deraisa or you're allowed to charge it. So any kind of an interest is going to be usher. So are you allowed to put in just a de minimis amount into the contract? Just so that there won't be imputed interest income, and so that the parties are not, especially the mom, is not going to be charged for extra income that wasn't even received in terms of being taxed upon that income. So I heard from Rabbi Ephraim Friedman, Shlita, used to work with me at the CRC, at the Chicago Rabbinical Council. He's now a Rosh Kollel in Aventura, Florida. So he said he heard from Chaim Cohn, Shlita, who's the Voyers Dayan. He heard from Chaim Cohn. Chaim Cohn thought that should be mutter, because there he says, like an Anan Sadi, it's like Dvarim Shibbolei V'lei Kol Adam, that everyone understands that this de minimis amount is just being written for purposes of avoiding imputed interest income. And under these circumstances, he thought that it should be okay. But I thought that here we're not just dealing with an Issa D'Rabbanan, we're dealing with an Issa D'Oraisa of Losi Simun Olav Neshech, and if there's any kind of a suffix, you have all kinds of posting. Mechokas Binyamin says that you have to assume that, in all of the contemporary Ribbis farm that I have in front of me, they all assume the halacha l'maisa, like the day that we do hold the Shuma Milsehi, that it really would be an issur just putting it down and writing, even if it wasn't intended to be collected. So I don't know. When people ask me the shaila, so I tell them that they can't put down such a. What are they going to do under those circumstances? They just have to take the hit in terms of paying taxes. No, you could do a heter. We'll talk about heter a little bit. Against all of these things are worth their own full-fledged shiur. This is just a hakdama. But I tell people that I think they shouldn't do it. I think that Rabbi Willig says the same thing. I think so. Right? Okay, we have a nod for the purpose of the tape. That it's something that is a very serious shaila of an issa d'oraisa. But you can ask the following question. This is sort of a more lumdish question, but we have the Kollel Elyon here too, so I'll throw it out there. How is there an issa to stipulate if I just said that in this particular case, the Tanai is not going to work, even if the parties waive any kind of objection. The Tanai is not going to work. So Al Pi Pashtus, it's not going to be chal altogether Pipashis is not going to be chal altogether. I mean, it's true that there is a discussion in the Gemara and Tamura about whether the Ribbis Ketzusa Yotze B'Dayanim is an example of, or the paradigmatic example, it's rejected, of the Machlokes Abai and Rava over there about Kamilsa Amar Rachmana L'Savi, Yavid Mahani, Yavid Lo Mahani. But the Gemara there says, well, we have sort of a Xeris HaKosov in terms of whether it's Nitan L'Heshavon or not Nitan L'Heshavon. But I'll be pashtus before you get to that question, which is discussed in the Gemara and Tzmura, about whether the question of whether Ribbis Ketzutza is Yotze B'Dayanim, which is Machlokas Rabbi Yochanan, Rabbi Elazar in the Gemara at the beginning of Ezo Neshech, I'll be pashtus, it shouldn't get off the ground altogether. The transaction shouldn't get off the ground altogether. But apparently, if we say that once the stipulation is made, even in a contract, that the Ribbis is going to get paid up, it seems so that if there is a violation of Losis Simun Alav Neshech right away, it seems that it really is chal. It seems that the stipulation is chal. So why shouldn't it be a batul mevutal? So a number of posts can point out that there really is, and Shlomo Zalman Auerbach has a tshuva about this in the Chelik base. Chelik base of Shlomo Zalman Auerbach is very difficult to look up because you have to figure out, do you have the hard copy version? They have the Bar-Ilan CD-ROM. The shuvas appear in different places. Sometimes they don't appear at all in one place, only in the other place. So this particular tshuva appears in both places. It's in Chelik base, Siman Sameches in the real hard copy version, and on the computer it's in Siman Ayin Aleph. So he quotes from the Abnei Miluim in Hilchos Kiddushin and Siman Chav Ches of Eben Ezer Sifkat and Chav Beis. So Abnei Miluim is of the opinion that it really is chal. That it's just a question of whether he's talking about sort of the flip side of the equation, or the backside of the equation, when it comes time for, let's say, Ribbis Ketzutza is collected. So if there really was no payment obligation altogether, and the Malva collects Ribbis Ketzutza, then he's Mekadesh and Isho, the Ribbis Ketzutza, so that should be outright Gezel, and the Kiddushin should not be Chal. But the Ritva says, based on his reading of the Gemara and Kiddushin, of Mekadesh B'Milveh, and Avach Yisebes Mana in Siman in Da'abav in Maseches Kiddushin. So the Ritva over there says that it's Masha from the Gemara. The Gemara asks, the Gemara says it's just like a haramis ribbis, but why isn't it considered to be ribbis ketzutza? She says that there's a question about the characterization, is it ribbis ketzutza or not? But the fact that the woman should really be mekudeshes, so that doesn't seem to be an afkamina according to the Gemara. So the Ritva concludes that even a mekadesh for ribbis ketzutza, the woman would be mekudeshes. And the Abnei Miluim that runs with that, and the Abnei Nezer runs with that, and Shlomo Zalman Auerbach runs with that. Shlomo Zalman Auerbach goes even further, and he says that even when the loan is originally set up, when the Ribbis Ketzutza is originally set up, so we see that there really is an obligation of payment. It's just that there's an isser on the malveh from collecting the money. Because of the isser ribbis, there's an isser on the malveh, just like there's an isser to stipulate to begin with. So there's also an isser on the malveh to collect the money, but really it is chal. For Haraya, the reason why the Gemara says that the Malva is obligated to return the money, according to Rabbi Elazar, whom we paskin like, is not because he says that it wasn't chal and it's a geneva, but because there's a chiyuv b'chei. That's why when it comes to the Yisomim who inherit the money of the Ribbis Ketzutza from the Malva who dies afterwards, so the Gemara says the Yisomim are not obligated to return the money. They're not obligated to return the money because they don't have a chiyuv hashava of b'chei achich. They didn't enter into the transaction to begin with, and therefore they're not obligated to return the money unless it's a davar mesuyam that's going to be an insult, or it's going to be an embarrassment to kavod aviyam, and the father really did tshuva before he died. They just didn't get around to return it, so then they have an obligation to return it. But otherwise, they wouldn't have an obligation to return. So Shlomo Zalman Auerbach asks a shayla. Shlomo Zalman Auerbach says this is all a very nice analysis and everything, but he says tzarchiyun medavazeh tzim kain kishemeis halove. He says that if this is the case, that the chiyuv really is one which does exist. It's just that the lover is not allowed to pay because he entered into a ribbis transaction. He can't pay the malva. So if the lover dies, my time bottom litain ribbis. So why is it? So maybe his children should be chayav to pay the ribbis because it's a real transaction. Like Rosh Zalman has a really strange nafkamina or hechi timsa type of nafkamina, which I have no idea like what the thinking is of like giving sort of this theoretical case. But he gives the following sort of hypothetical case. He says, let's say that the mom and lova would enter into a transaction, and then HaKadosh Baruch Hu would do away with the Yisur Ribbis. I partially don't understand where like such a hypothetical is coming from. He says the Kosh Baruch Hu would do away with the Yisur. He says this. I'm not making it up. He says, so he says, so it would follow according to this analysis, the Avnei Miluim and so forth. So it would follow that under those circumstances, since this really was an absolute obligation, it's just that the lova wasn't allowed to pay because the Yisur Ribbis. Since the Yisur Ribbis went away, so then the lova really would have an obligation in such a case to pay. So that Hekatimsa I can't relate to at all. Because we assume that Torah is not going to change. But but here he asks a viable question. He says that we find this is not true. We don't find that we find the lova is not obligated. The children of the lova are not obligated to pay, even if the father had died. So this sort of casts a question mark about whether there really is a chalos at that point in time. The truth of the matter is, yes, question, Dr. Cooper.
You said something about an esrog also, the word esrog. That it's not no problem with Lachem because we belongs to Malva now.
If it would be, let's say, an esrog, it would be, and it would go to the malve. This would be the Ribbis Kitsutza that would be paid. Al pipashtus, yeah, yeah. Then now, of course, this is all within the Ritva. Not everyone agrees with the Ritva. When where the Beis Shmuel and Siman Chav Ches and Even Ezer quotes the Ritva, so he's quick to point out that Rabenu Yerucham disagrees with the Ritva. Rabenu Yerucham says that if you're Mekadesh Ribbis Kitzutza, the woman's not Mekudeshes. I don't recommend it. So it's certainly a machlokas haposkim. And it could be that if you assume like Rabenu Yerucham, so it's not so pashut that we would necessarily say that there was a chalos. But also you can explain the case where the lova actually paid the money, that if he paid money, let's say, even if he wasn't supposed to pay the money, let's say that really the whole Tanai was essentially batal mavutal. The Torah is exeris hakasuv. That even though the Tanai is batal mavutal, is exeris hakasuv. It says those is siman olav neshek. That nonetheless, there's still a violation to stipulate that you're going to pay ribbis anyway. And then the lova down the road, this money that he's not obligated to pay, we wouldn't be motzi the money from the lova. The money that the lova is not obligated to pay to, he pays to the malvis. That's a different story. We could say that maybe he's even though he wasn't obligated to pay, so he paid something he wasn't supposed to pay. It wasn't a viable obligation, but nonetheless, there's a question that maybe it's considered to be a mechila. Like you could bring a raya potentially from the Taz. You'll say the Taz has a special sheet. So the Taz says that even though Ribbis Ketzusa Yosef B'dayanim, so the Taz holds that it's only if the Loba asks for it. But why does the Taz say that it's only if the Loba asks for it? The Taz says that because otherwise he says that right away, once he gives the money, there's implied mechila. It doesn't apply. The Loba didn't never heard of Hilchos Ribbis altogether, so none of this applies. And of course, it has to be returned to Loba. But he knew about Hilchos Ribbis, and he gave the money right away. So he gave the money when it was time, whatever. So the Taz says that he has to ask for it in return, but it could be as well. But it's not a question of was there really a chalos to the obligation? It could be it's a question of once the money is paid. So maybe then it would there would be a mechila at that point in time. If you wanted to bring maybe a better raya, so maybe you can bring the raya from at least the shita of Rova Poskim. Rova Poskim hold. Let's say I have the following situation. There's a Ribbis transaction. There's a Ribbis transaction between the Malva and the Lova. And now the Malve finds out he's not allowed to collect ribbis. He didn't realize he's not allowed to collect ribbis. He became a Baal Tshuva. Now he found out he's not allowed to collect ribbis. So he knocks on the Lova's door and says, I just found out I'm not allowed to collect the ribbis. I was relying upon the fact that I'm giving you so much time to repay the loan because I'm getting a 12% and 15% premium and all that. Now I know I'm not going to get any premium. I'm only allowed to collect the principal. Or best of all, give me back the principal right now. I want it back immediately. I gave you originally 6 months. I gave you a year. Now I want it back right away. is I'm not going to get the premium. So is the Malva allowed to do that or not? So Rova Post in the Bris Yehuda brings this in Parak Alpha over Memdalad in the Bris Yehuda, and he brings that the vast majority of poskim, including the Mishnah Melech, the Machane Ephraim, the Chabas Das, they all hold that under these circumstances, and this is the way that most poskim, the Chilkas Binyamin assumes that this is how we paskin as well. The Malva is allowed to ask for the money back immediately. So you could say, so if that's the case, if I would say that it never got off the ground, that if the Tanai was batul, I would say Tanai batul ma'isa kayim. That the Malva said you have 6 months to pay. So he said you have 6 months to pay, but you got to pay, Ribbis. And now we found that he can't collect the Ribbis, but the love is still 6 months to pay. So the fact that he can now say that it turns out that he can't collect the Ribbis, but so that he has the right to now invalidate the entire transaction. So maybe that's an indicate that there is some sort of a chalos in terms of the entire package. So it's not entirely clear to me. But I don't think that any of the rayos of 100% muhwach, but Rosh Zalman certainly does assume that this counts as mum. And he also brings a raya from Rashi, who in the Havamina of the Gemara, when it was describing sort of the machlokis between the Tanakam and the other Tanaim, regarding whether the shtar gets whether this is sort of a you can rectify the yisur by repaying. So he talks about the Gemara says maybe they're arguing about whether shtar omi the gabas kagavoi dami, and therefore the Arab and the Edom, everybody already violated the yisur right away. And Rashi says on that Havamina sheharei shibi lo kakaosav ala kevin re'ala Ribbis. Because after all, the Lovet has mortgaged basically his properties for purposes of the Kevin and the Ribbis. So it sounds from Rashi that he's understanding that there is some sort of a shibud with respect to both the Kevin and the Ribbis. But of course, that's only in the Havamina of the Gemara. The Gemara in the Maskana says, according to both Shitos, and maybe that theoretical explanation by Rashi was only an explanation in the Havamina, not in the Maskana. So I leave that as sort of like an open question, but one which you'll have more of an opportunity to consider as we continue to learn Hilchos Ribbis over the course of the year. But I would argue that even if you would say that it's the Tanai is batul mabuto, certainly in terms of being enforced, I don't know that that's necessarily a contradiction to holding that there is a violation simply for just entering into the stipulation of los simonol of nesha. You could argue that it's a shtickle raya that it gets off the ground, but I'm not 100% sure. So one very important principle with respect to Hilchos Ribbis that the Gemara talks about, this is in Bar Mitzvah Daf Samach Tes Amud Beis, is the idea of lo asra Torah ela Ribbis abami lo v'lamalva. That the only thing that the Torah forbids is the Ribbis that comes directly from a lovet to a malva. Therefore, we have these sort of interesting scenarios where, for example, you have somebody else who gives some extra money to the malva, and it says, here, take this money and loan an interest-free loan to the lovet, so that's 100% permissible, right? Or the lovet himself goes to some person whom he's going to hire, let's say, as a broker. And he says, this person, I'm going to give you some money so you will convince the malva to give me an interest-free loan. So in all these cases, despite the fact that it seems like there is some ribbis which is getting paid, nonetheless, it's mutter, not just mutter midaraisa and also midrabanan. It's mutter midaraisa, it's mutter midrabanan, mutter, 100% perfectly fine. If it's not ribbis, which is haba milove lemalve. So the Torah Tamima, who is a banker, Baruch Epstein was a banker, and he has a lot of very clever, thoughtful things to say about Hilchos Ribbis. I think he had a very good understanding of financial markets and the like. It's a wonderful, beautiful explanation of why the heteriska is not considered to be a harama, which you probably heard about if you already heard your first year of the year from Rabbi Feldman yesterday. And he spoke about harama and Hilchos Ribbis, right? Did he talk about that yesterday? I assume he did. So the Torah Tamima on this on this particular question, he points out that let's just put aside for the moment the fact that the Gemara at the beginning of Ezu Neshek tells us that there's no real meaningful deraisa difference between Neshek and Tarbis. He says there really is. There really is. That the idea of every single Ribbis transaction, in order for something to constitute Ribbis, you need two different features to be in place. You need that to be Neshek, that the lova is bidden, and you need Tarbis, that the malva is getting extra. So he says that in the event that in both of these cases scenarios, where you don't have Ribbis above milova l'malva, what you really are saying is either lova is not getting bidden, or the malva is not getting his extra amount. Either there's no neshech on the part of the lova, there's no tarbis on the part of the malva. If it is that the lova is paying some other party to talk to them, to sweet talk the malva into giving the lova a loan, so there's neshech from the lova, but there's no tarbis that the malva is getting. If it's some other person who's giving some extra money to the malva, so he'll make an interest-free loan to the lova, so the malva is getting tarbis, but there's no neshech that's coming from the lova. So he says that in your typical Ribbis situation, where lo asra Torah el Ribbis above milova l'malva, which the Gemara seems to learn from es kaspicha lo sitein lo, that it's the lo sitein lo, the lova is not allowed to give directly to the malva b'neshech or b'marbis. How do we know that it's talking about a loan? Because Pashtus is, that's what we're talking about, is talking, when else would you be giving extra money? Must be a loan transaction. Some of the poskim say that this pasuk, which is in Parshas Bahar, is really a continuation of the whole Parsha of Ribbis that began in Parshas Mishpatim. Im kesef talvei esami, sani machlo sielo kenoshev lo sismun alav neshech. Im kesef talvei esami. That's the whole lo sismun alav neshech is all premised upon that there's a hava transaction. So now we're continuing there. Now that we established that that's what we're talking about, when we speak about neshech, it's always a hava transaction. So he says lo sitin lo. So we know that the Torah only asks Ribbis haba milov l'malva. It has to be a hava type of transaction. It can't be like, for example, a mecher transaction. If it's a mecher transaction, I can have the two parties. I have the two parties, but I don't call them lov and malva. They're not lov and malva. The mocher and koneh. That you sell me some things and you tell me if you pay today, it'll cost $100. You pay a month from now, it'll cost $120. So we all know that's considered to be ribbis, but it's only ribbis d'Rabbanan. It's not ribbis d'Oraisa. Why? Because there's no malva and a lover. There's only a purchaser and a seller. So you need a lot malva and a lover, and it has to be direct. So says the Torah to Mima, since this is the idea, the idea is that somehow the lover is losing and the malva is gaining in terms of the payment of the money. So he says the following Kiddush. He says this is why this the Shita that's quoted, the Ramah quotes it from Chaburah Rashi. Others say it was some Talmidim Toim. It was Talmidim who weren't paying close enough attention in Shir. Maybe they just listened to Rashi like on double speed afterwards, so they didn't get it 100%. So so it was the Talmidim Toim. They think that Rashi said such a thing, that he said what? That because of this principle, therefore, let's say that the malva only loans the money to lova to a shliach, and the shliach then only pays back to, the lova only pays back to a shliach. So therefore, that's not ribbis haba milova l'malva, because there's a shliach in the middle. The whole discussion about how that applies in this particular case. But either way, so that's what Rashi is arguing. The Tshuvas Rashi that the Ramah quotes and doesn't seem to completely discard either, although the Nosei Kelim to take care of that particular task of saying do not ever rely upon this. That should be, strictly speaking, that should be mutter, even midrabanan, because it's not ribbis haba milova l'malva. It says the Torah to me, well, that's crazy. Torah Tamima says, now that I've explained to you what it means, that it can't be something where the lova is losing and the malva is gaining. That's exactly what's happening over here. Who cares that it's being sent ayidei shliach? The lova is paying the extra amount, the malva is gaining the extra amount. So he says, this goof, sure. Of course, this is ribbis haba milova l'malva. Now, the cases which are not ribbis haba milova l'malva are the cases that were discussed in the Gemara, where you have third parties that are either getting the money or paying the money, as the case may be. But there's more to this principle than meets the eye. It's not just these couple of scenarios that the Torah Tzmima beautifully explains. I mean, it's kind of like Yisrael Reisman has a couple of chidushim in his book that are eye-opening and that maybe others would disagree with. But one, he just throws in like a footnote on page 82 of his book that it doesn't quote anybody. It doesn't quote anybody. Just like has it as a footnote, and I have to say that I was startled by it. But I'm not making it up. You could look it up for yourself. So he says like this: let's say that a malva and lova already entered into their loan transaction, and now they realize that they're not allowed because there was ribbis, and they're not supposed to charge interest. But on the other hand, they want to, like the lova, does tshuva and he wants to correct it. So one way to correct it is, okay, so make a heteros at this point in time. maybe convert all the payments that were made to principal and have a higher level of interest, maybe do a kinyan back and forth of the amounts, and now it's going to be relended, or rely on the dogomer bava that you could just do a kinyan without transferring the monies back and forth and just start a heteriska at this point in time. Just fix it. We know that there are different ways of fixing it. But the Malva is not interested. The Malva is the same anti-halakhic personality who insisted on putting the Ribbis provision, in the contract anyway. The Loba didn't know any better at that point in time, but now he knows better. And the Malva says, nothing doing. I'm not doing any heteriska. I heard the CRC had a case where they took the heteriska seriously and they didn't make the person pay all the money because they really lost their shirt. I heard there was such a case. There really was such a case. So I'm afraid that with a heteriska, I'm not going to be able to collect all of my money. I'm not doing a heteriska. So, but he said, if you look in the loan documents, it says if you don't pay the Ribbis is just going to get compounded, and you're going to have to pay a higher interest rate, and it's just going to get worse and worse and worse. So you know what? I really recommend that you pay, because otherwise I'm going to enforce this contract in court, and you're going to be in a lot of trouble. The law doesn't want to do that, because it is Ribbis on the lover as well. So he doesn't want to pay the Ribbis. But if he doesn't pay the Ribbis, it's just the obligation that he's going to have is just going to become much greater and much greater. So what's he going to do under these circumstances? So even, in order for him to avoid paying the Ribbis, maybe if it's only enforced in court and it's taken away from Baal Kocha, so maybe that's not considered to be a payment of Ribbis. It's Baal Kocha, he's being stolen from, but he's still going to lose all of his money. So what do you do? What's the law do in that case? So Rabbi Reisman said, no problem. I have an idea. We have Gevirim. In the Jewish community, Baruch Hashem. So I have him go to the Rav of his shul, explain the situation, and then the Rav will get a Gevir who will go over to the Malva, and the Rav will explain very politely to the Gevir that this lover is in a very difficult situation because he owes all of this money, and maybe if you could just pay this money on his behalf, you'll pay the money. The Ribbis payments you'll make on his behalf, so it won't be Ribbis haba milove lemalve. And then after everything is paid up, and hopefully this fellow will get on his feet. And so then the lover will, or he may already be on his feet. That wasn't the issue. Then the lover will reimburse this Gevir at that point in time. So I was thinking, whoa, reimburse the Gevir. Isn't that like doesn't the Shulchan Aruch say beferish that the lover is going to reimburse? So then that's actually problematic if the lover is going to reimburse. Even the Shach who says there's room to be made wasn't talking about that case to be made. It was talking about a case where the lover maybe asked the person, and initiated the request that this person pay extra to the lover. So maybe the evidence you can make on that case, but none of the Nosei Kalim say, as far as I know, that you could be makel that the lover can reimburse the person afterwards, and we'll still say that that's completely legitimate. So I'm stymied. I recommend you look at that footnote, and maybe you have a good explanation as to why he felt that works. But he thought that might be okay. It could be the Nesiva Shalom has this idea that if you have a third, maybe this is what he meant. That if you have a third party comes along and he pays the Ribbis on behalf of the lover, but he says to the Malva at that point in time, I'm paying this amount in order to get my friend off the hook, I'll tonight, but on condition that you accept this as a matana from me, and you waive the Ribbis. Because of the fact that I'm giving you this amount of money, I want you to waive any kind of obligation that he's going to have to pay interest. This is not an interest payment. It's not interest payment. I'm giving you a gift. A third party giving a gift. So the lover gives a gift, so it looks suspicious, so we don't allow that. But a third party is going to give a gift. I'm giving you a gift, but I'm only giving you this gift on condition that you're going to waive any kind of interest obligation. And then afterwards, the lover reimburses him giving the gift. Okay, so maybe that's a little bit of a stronger argument. I still don't find that necessarily compelling, but maybe he just figured that this lover is in a bind, so this is better than nothing. Maybe the suggestion is better than nothing. Also based on this principle of Torah Asra Ribbis Abami Lova L'Malva. So again, there's more to be said on this subject because Lova and Malva. Who's the Lover? Who's the Malva? So Moshe Feinstein has a very important chiddush in Hilchos Ribbis, which seems to be against the Gemara about Messiah and Daf Samak Dalet and Aleph, but okay. But Moshe has a chiddush in which he says that if there is no shibra guf on an individual is not personally liable for the obligation. He has certain assets that are on the hook. Where there's a corporation which is owned by lots of shareholders. The shareholders have their own individual money and assets in the shirt on their back, but none of that is going to be subject to collection. The only thing the Malva will be allowed to collect from will be the assets of the corporation. It's only Shiba Nechasim and not Shiba Guf. Think about the distinction between the two. A person sells a shtar chov. The Ryan quoting Rabbeinu Tam, he's only selling a Shiba Guf, not Chasim, not Shiba Guf. That's why the person who sells it is still allowed to be Mocha the Chov. The whole story. So he says we see that there's a distinction between Shiba Guf and Shiba Nechasim. If the individual only has Shiba Nechasim, it's not on the individual, it's only on the assets of, let's say, the corporation, but the individual shareholders are not going to be on the hook. They're not going to be personally liable. Then there is no love. There's no love. Love implies a person with personal liability. That is a love. Otherwise, there's no love. No asra Torah, ela ribbis haba, love, no love over here, no harm, no foul. And therefore, it's perfectly permissible for a corporation to borrow money from a Jewish individual with Ribbis, as long as there's no personal guarantor, and to pay the Ribbis. It's 100% heter gomer. The Gemara talks about a person who makes an obligation only with respect to the yield of his the milk that's going to come out of his izim, and the Gemara indicates that that would still be a Ribbis midrabanan. Okay, I don't know, but Moshe presumably has an answer for all of that. But Moshe holds that this is considered to be heter gomer. Others, like the Cheskisa, Shlomo Zalman Auerbach, they say, well, no, from the Gemara, it seems that it's still going to be Avak Ribbis, but Moshe has a point. He has a point. We've heard that statement. He has a point that maybe it won't be Ribbis Daraisa, but at least be Ribbis Darabanan. So, okay, even the others hold that there is an argument to say that it's not, the person's not a loba in terms of being Ribbis Daraisa, but Moshe goes even further to say that it wouldn't even be considered to be Ribbis Darabanan, but Moshe goes in case you think that Ramosha was only talking about corporations. Ramosha tells you explicitly that's not true. Ramosha says that let's say you take money, a loan from a bank, an individual, a person, not a corporation, takes a loan from a bank, a Jewish bank. You take a loan from a Jewish bank or a Jewish banker, and you have a non-recourse loan. It's a non-recourse loan, which means that the bank is only allowed to collect from the real estate, only allowed to collect from the property, and not from the personal, any other personal assets of the individual in question. It's only a piece of property that has been flagged for collection, but not the shirt off of the lover's back. So says Moshe, that also is mutter. Yes, he says it. He really says it. He says it beferish in his chuvas. I wouldn't have thought so, but he does. So Moshe says that this is not only applicable to, because I found it originally Rabbi Reiss, and I said, nah, that can't be. But then I looked in Taka, where Moshe says it. He says that even a non-recourse loan, would not be subject to Ribbis, not Ribbis Daraisa and not Ribbis Darabanan, because there is no Shiba Guf. So that's a very, very big kula. And we don't rely upon it sometimes in a b'diavad situation, so Moshe becomes irrelevant. And certainly in terms of knocking down an Issa Ribbis to a Darabanan, it becomes relevant the Chol Hadeh. So Tzvi Pesach Frank applied this idea in a different context. He said that he wasn't talking about a limitation in terms of Shiba Nechasim versus Shiba Guf, but Tzvi Pesach Frank asked the following question. Let's say with respect to Israeli bonds, where the Israeli government is on the hook. When I was growing up, this was a very, very big deal. Investing in Israel, it's still a big deal. I assume many places to invest in Israeli bonds, still a big deal, but it's like an even bigger deal. When I was growing up, like this was like, you look at the who's who in any Jewish community, they were on the board of the local Israeli bonds chapter. That was like a very, very, big cause. And people felt very strongly about it. But the question was it all Ribbis? Because Israel is paying the principal back, plus they're paying interest. So why isn't that a problem of a Ribbis? So the truth of the matter is that the Israeli government did do a heter iska. It's a question of, does the heter iska really work? Can you bind the government? Maybe there are restrictions regarding how the money can be invested and so forth. They have the right to invest. Okay, whatever it is. But they did do a heter iska, I think, for purposes of Israeli bonds. I saw it. I saw the heter iska. It was done in the early 1950s or so. And now we're very familiar with all of these streamlined, beautiful forms of heter iska, exactly how the heter iska works and so forth. This looked nothing like any of the forms that we're familiar with, and I hope it worked. But in any event, they redid the heter iska that was done in the early 1950s, about 15 years ago, of Shlomo Amar. He made a lot of tikkunim when he was chief rabbi, somebody that really should be tremendously appreciated. Shlomo Amar did a new form of heter iska for the Israeli government, which had all the lashonis and all the hidurim that they were familiar with. Wonderful. But Tzvi Pesach Frank came along and he said that I don't think that there's even a need for a heteriska because of the fact that there are no bailim misuyamim. He says that that you need to have just like Moshe spoke about shibud nechasim not being enough for there to be a love. He says there's no love because there are no bailim, misuyam. There are no individual people. It's just a government, a bank, a memshalti, ein l'shum yachid, skus bailos. Let's in a moment. You could say with a bank or corporation, okay, there are the shareholders. Here, there are no shareholders. There's a difference between a conglomeration of individuals and a government. A government is sort of a standalone entity. I'm not sure if Abraham Lincoln would agree, but he says a government is sort of a standalone, right? It's not other people, by the people, for the people. But he says a government is a standalone entity. It does not consist of actual individuals. And therefore, he says that for this reason, he doesn't think that there is any kind of a problem of ribbis altogether, because there are no bailim misuyamim. He says in both, he says that there's no individual who has any kind of bailus on the money that's being invested. So therefore, his chiddush was that because you don't have bailim misuyamim, you need like an actual person that can be pointed to, but if you can't point to an actual person, so then there is no lobe in the picture. Rav Yona Reiss has a different idea with respect to corporations. One second, where he also says that corporations, not for the reason of Ramosha, that there's no only shibud nechasim, not shibud aguf. He's not so keen on that reason, but he says that he thinks that there's no human being that really constitutes the owner, because in a corporate normally, when you have a human being that is receiving money or who has some sort of a memshal or has ownership over money, so the human being has sort of the right to the dividends of the money, what it's going to yield, makes the decisions from day to day with respect to the money, and also that individual makes all the major existential determinations regarding whether the money is going to, or the whole project is going to be sold or given over to another individual, whether you're going to wind up the affairs of this particular enterprise, etc. But he says in a corporation, all of these three different functions are split between three different entities. You have the shareholders who get the dividends. You have the board of directors. You have the chairman of the board who makes the day-to-day decisions regarding the company, and you have the board of directors that makes the existential decisions with respect to the company as to whether you're going to do a merger or acquisition or winding down of the company and so forth. And because these different indicia of ownership are split three different ways, therefore there is no actual individual ownership. Rather, it's considered to be a legal entity. A legal entity is not considered to be a love, not considered to be a malvi. Remember, Moshe was only making in the direction of saying that the corporation could borrow money because it did not have a shibud haguf, but only shibud nechasim. But if you would have a Jewish-owned entity that would lend out money, so then the lending out of the money to an individual Jew would still be usher according to Rav Moshe. The fact that you're borrowing from a bank doesn't help according to Rav Moshe. According to the Minchas Usher, even that would be permissible. It's just important to note. It's a disclaimer. He does say that since when it comes to like Jewish banks and entities and things of this variety, that it's something that you have to worry about, and that we don't just consider it to be a legal entity, but we consider it to be a personal entity, a conglomeration of individuals. And who was that chacham who was machmir about this? That was none other than the Kitzur Shulchan Aruch. Kitzur Shulchan Aruch of Shlomo Ganzri was very machmir, even if you only have a minority ownership in a particular entity. He was talking about banks by a Jew. He was machmir, and others disagreed with him about that, but he clearly held that there was a Ribbis problem. So he said, okay, fine. So I'll grant you Ribbis. Okay, Ribbis will still be machmir about it, even though I think that there's really no problem with respect to Ribbis. Said the Minchas Usher will be machmir about Ribbis. Okay, so it'll make you all happy. Says, but Chometz B'Pesach, I think we could be makel. So he goes off, other areas where he thinks you could rely upon him. But here he says he thinks that you can, he thinks you could be makel. Again, getting to the question of what's a lova, what's a malva. And the Rashba really began this discussion with respect to a malva. The Rashba said that when you have a staka entity where the money is really just being held for the benefit of stock institutions for aniyim, but no specific aniyim, so the Rashba said he thinks that there really should be no Issa Ribbis. There really should be no Issa Ribbis, and you should be allowed to loan out the stock of the Gabbai of the stock of funds should be allowed to lend out without any problem or without any restriction whatsoever, because there are no bailim yuduim with respect to holding stock of funds on behalf of the community. What he said that because of the fact that this would create a pirza, that if we relied upon that, so that would be the end of Hilchos. That would be the end of Hilchos Ribbis. So therefore, he didn't want to rely upon that. But in a step, that's one shuva that's quoted by the Beis Yosef and Simon Kov Samach. There's a different shuva quoted by the Beis Yosef, the Shuva Acheres, where he says the same thing. But he says that he also. That although he wouldn't rely upon this for Ribbis Daraisa, he would rely upon this for Ribbis, which is various forms of Ribbis Darabanan. So we see that if if the Malva doesn't have Bailam Yuduim, at least according to Shuvah Sarashba, there's room to be Mako with respect to Ribbis Darabanan, even though at the end of the day he was only Mako for the case where the Gemara was Mako when it came to Moshe Yisomim, which was Rakok Mehepsid Vekarov Liskar. And later, authorities, of course, took the dispensation of the Gemara with respect to Moshe Yisomim and did away with any need for the Rashba altogether, because they said, number one, if Rachok Mehefsin and Karv L'Skar is mutter, so all Ribbis Darabanan is mutter. The Gemara didn't say that, but okay, good enough. And number two, if it's mutter with Moshe Yisomim, it's mutter with any kind of Moshe Tzedakah whatsoever. We're going to be Mako, again, not based on saying that they're not a Malveh, but according to the Rashba, this was based on the Svara that if you have a sort of stock of funds, not Moshe Yisomim, maybe that belongs to the Yisomim, it does. But if you have stock of funds, he held that there was no Bailam Yuduim, and that was a basis to be Mako, at least with respect to certain forms of Ribbis Darabanan. Yes?
You don't go as far as Rav Yona Reiss, but if you just felt it like the two that's on francs. So what would the status be of like a subsidiary company, meaning where a company owns another company, that like internal one considers to have Bailam Yuduim because of like the parent company's shareholders, or do you recognize that?
No, if you keep on, I mean, in my opinion, if you keep on going up the chain, eventually you do find Bailam Yuduim, so then it's considered like all of the lower point entities would be viewed as having Bailam Yuduim. That's what I think. What? No, because the Street Pesach Frank holds that the government is considered to be like a separate entity altogether. So just it's not a conglomeration of individuals. That was his understanding of how the government works. I remember with Quicken Loans, when we had sort of like the whole Shiloh a number of years ago, that he had loads and loads of Jews who were taking loans from Quicken Loans, and there was a Jew who owned it. His name was Dan Gilbert, I think. So Quicken Loans was getting used to these Shilohs. Like, the people who are answering the telephone. So they train. They have like their frequently asked question FAQ list. So they were trained. What do you do if some Jewish person wants to take a loan and they say, oh, do you have a heter iska? So they had your standard answer. Somebody shared it with me, like, that this is what they're all staring at. If somebody asks a question, oh, we don't need a heter iska because Quicken Loans is not actually owned by a Jew. It's owned by Rocket Mortgage. So then the next question is, okay, so who owns Rocket Mortgage? Oh, Dan Gilbert. But that was the standard answer that they gave. It's owned by a different entity. But that entity was ultimately owned by a Jew. So therefore I had to explain to these people that doesn't really help. And for a long time they wouldn't accept as an answer. No, but we have the FAQ right in front of us. Obviously it does help. But it wasn't written by a posek, the FAQ. So eventually they came around and they did a heterisk. That's a whole separate shear as to whether that heterisk is considered to be a good heterisk, but at least it is posted on their website. So that itself is pretty impressive. Yes.
Moshe and Rosh Wise, was enough
Nafkim Elaisis, the Street Pesach Frank was only Mako with respect to if there are no Bailam Yuduim. Rav Moshe was talking about there are Bailam Yuduim, but they don't have personal liability, and he held that even that was mutter. Street Pesach Frank didn't hold that was mutter per se. So that would be an afkamina between them. Yeah. So now on this particular subject, so another important look. Some other applications of Loasapari Ribbis Habam Milova Lamalva, just one common one. We all know that there's a problem of loaning out your credit card to somebody else, because that's considered to be, if the person who's using the credit card is then going to be obligated for the interest charges on the credit card, so then it's considered like they're really paying you because they took out a loan from you. You took out a loan from the credit card company, which might be not Jewish, that's okay. Then this person took out a loan from you, and if you say to the person, oh, I want you to pay a third party, so we know that midin arav, that's considered to be a problem of Ribbis as well. So that's considered to be a problem of Ribbis if you direct that the money be paid to a third party. However, let's say that I loan the money out to somebody else, and that person now makes all kinds of acquisitions, but now I get points. For every single one of the acquisitions that the person makes, I get points on my credit card that I can use for airline tickets and for grocery shopping and all of these other things. So that's not a problem, because the the points aren't coming from the Lovet. Lovet's not giving me the points. The credit card company is giving me the points. No problem. So the post can point out that would be perfectly fine. So we have a lot of applications just throughout. Rav Wind has in his sefer, I have no idea how common this scenario is, but he spends like 3 pages on it, where you have Avos Ubarim, the learning on Motzei Shabbos, and one of the boys wins a prize and the other one doesn't. He has like a candy bar. So the father says to the boy, oh, if you give like half of your candy bar to your little brother who didn't win, so then I'll give you like a full candy bar in return. So you can't do that, because then that's considered to be an Issa Ribbis, because he's loaning a half a candy bar, and you're telling him he's gonna get a full candy bar, or he's gonna get a full candy bar back. So he says that, however, if you structure it in such a way that the candy bar, that the principal of the candy bar, half of the candy bar will be paid by the other brother who's getting it, and the extra amount will just be paid by the father, but he doesn't so it's not Ribbis above Milova Lamava. I understand that, whatever. But this is whatever, you figure out in every single case. But that's certainly a relevant consideration. Now, the second thing I wanted to discuss, not second thing, but there's the next principle that I wanted to discuss in terms of the sort of the basic principle. So this idea of Moshe Yisomim, that you're allowed to lend out Ribbis, that's the halakha of Rav Sheshis. So this also has all kinds of ramifications for tzedakah institutions. Once we paskin in Shulchan Aruch in Siman Kuf Samach Sif Yud Ches, that tzedakah institutions are allowed to lend out Ribbis. If it's a Ribbis D'Rabbanan, so then this becomes a whole big discussion, because we said even if we're starting off with a Rashba, we're not going to allow Ribbis D'Oraisa, we'll allow Ribbis D'Rabbanan, or so it becomes sort of a whole big question mark of what nowadays is considered to be, number one, a tzedakah institution, and what's considered to be Ribbis D'Rabbanan. And this is very relevant, obviously, to Yeshiva University, any loans, student loans that people take from Yeshiva University. So I get this question pretty often with respect to people who, I don't say pretty often, I get like once a year, with respect to people who are students at Yeshiva University. And Rosh used to have this chiddush, because there's a Ran in Suastaf and Vav, it talks about how we have sort of a cloud to cloud when it comes to Ribbis that would exclude, that's something which is Davar Mitalto V'Gufa Mamon, it would exclude Kakos, it would exclude Shtaros. So even though we don't really seem to paskin like that day in Shulchan Aruch, because we do say that even Karka is going to be Asa, but maybe it's only Asa Midrabanan, okay. So it could be, the Ran says that any Shtaros also, it's not Gufa Mamon. So the Ran says that also is included. There's a Tosfos there, and in Ezu Neshech, that indicate that according to this day, a karka is only Ribbis D'Rabbanan, and the Ran says included with that is that shtar is only Asa Midrabanan. So for a long time, Shekler was saying that since most loans nowadays, some stock institutions or student loans are made by check, and you're giving it back by check, so therefore that would only be Ribbis D'Rabbanan. So that was a possible reason to be makel if you're dealing with a stock institution like Yeshiva University. However, nowadays nothing is really done by check, or very little is paid by check anymore. But now you had a different heter, which is that it's not really a hava, it's mecher, because you're receiving a service. You're receiving a service of an education. It's just that why you were saying, instead of having to pay right away, you can pay later. And if you pay later, it's going to be more money. So therefore, that's not Ribbis D'Oraisa. That's only considered to be Ribbis D'Rabbanan. When you're paying later, you're paying in sort of compounded interest. And if you're paying in compounded interest, so arguably the Shulchan Aruch Harav says that even if it's a mecher transaction, if you're paying with compounded interest, that is Ribbis d'oraisa. So I don't have an answer for that, except to say maybe we don't hold like the Shulchan Aruch Harav. But assuming that the whole thing would really only be Ribbis d'Rabbanan, so he said maybe that would be what we can rely upon. And you should know, for the record, that when I was the Manayel here at Yeshiva, so I decided that maybe the time had come that why you should have a heter iska. So we put together a heter iska at that point in time, and we discussed it. And Rabbi Bleicha Shlita came up with a whole text for resolutions and so forth. And if you look at the end of the materials that I sent out, I actually have the text of the heter iska that was eventually adopted by Yeshiva University, which had some resemblance to whatever it is that I originally sent to them. But one important part of the text of the heter iska is that it says that it's automatically applicable to any transaction of Yeshiva University that requires a heter iska. So that even if a student did not specifically ask for a heter iska, arguably the heter iska would be applicable in their particular case. And I know that it's somewhere because the general counsel's office sent me a copy of it maybe 6 years ago or so to show that was what was on the file. And now if anybody asks them about a student loan and making sure that it be done, I'll be heter iska, so there not be any Ribbis problems. So the general counsel's office contacts me and says, Rabbi Reiss, I think you have a copy of it, so can you send it to them? So I said, well, you're the ones that sent it to me, but that's okay. So it does, let's assume, exist, even if only in the form of the emails that the email that was sent to me at one point in time. Nowadays, all important records live in cyberspace anyway. That's how things get filed. That's again. The big question that I have as well, in terms of relying upon Ribbis d'Rabbanan, where I feel that heter iska is probably more important to university, is that what defines a stuck institution? The person's going to the college, so maybe, I don't know, does it depend upon like which yeshiva program they're in? I'm not 100% sure. Or let's say that there's like the student loan. We always say we don't charge for the learning. We only charge for like the college education. So is that really stuck institutions account? Does it depend on your perspective towards MADA, whether MADA has like, some sort of a higher level purpose of teaching Yira Shemayim? But certainly if you have a student who's going to the law school, I don't know. I think it's a bit of a stretch, probably a bit of a stretch. If it's a question of a student loan for the law school, to say that this is a stuck institution, I mean, maybe in the broad sense it is, but I leave that for further consideration. Okay. Now another next important principle I want to discuss. Kollel Rabisa. The Gemara says, Kollel Rabisa, call agonater or agonater is usher. What does that mean? Kol agoneter is usher. This is the Gemara on Daf Sama Gimel Amud Beis. Pashtus is that it means that in order for it to be Ribbis, it can't be like, for example, that I'm giving you something, some money, and you're giving me an item which is discounted because I gave you money, so you're giving me a discounted item. If you're giving me the item right away, so obviously that's not Ribbis d'oraisa d'Rabbanan because you're giving me something right away. In order for something to be considered to be Ribbis d'oraisa or d'Rabbanan, there has to be a delayed payment because of the fact that the person who gave the money is willing to wait for the money, so the person who got the money is willing to pay more money. That's the idea of kol agar neter aser, that there is payment for a delay of money. You could say it's a payment for the rental of money. Payment for the rental of money is a dangerous thing to say, because rentals are mutter. That's the great contradiction in Hilchos Ribbis, is that Ribbis is aser, but rentals are mutter. Why is it rentals are mutter? I can give you property. I'm renting you property. You use the property, so you're getting a benefit of the property, and then you return the property to me. You're returning the keren of the property, and you're also paying me for it. Why is that not considered to be Ribbis? Okay. So whole simon in Shulchan Aruch about that. You're paying for the depreciation of the item, or if it's the same item, and milvis lahosanin, if it's the same item, so then there's no problem of Ribbis, even if it's a problem, if an item that doesn't depreciate, if you didn't have the right to give me a different item, but only the same item. So those would have to be the two aterim, because, and this is an important principle of Ribbis, you have to understand this, that ultimately Ribbis is when you got something that you're allowed to use for yourself, and it basically goes into your property. And now you're paying me in addition to the value of what you received from me that went into your property, but you're paying me extra for what went to you. But if it never left my possession, this is the whole Makabel Tzom Barzel Sugya. If it never left my possession and it was always mine, so then there's no Ribbis, because I have the right to charge you for what is mine. So bear in mind, like that's a very, very large part of what Hilchos Ribbis is all about. Is it still mine, or did it go to you? And a lot of that has to do with, do I still have a chrayas over it? If I still have a chrayas over it, the more I have a chrayas, the more it's still mine. The more that you have a chrayas over it, because you have to pay me no matter what, so then it's yours. So then we have a Ribbis problem. This is what I would call the Kollel Ribbis that we're really talking about over here. So this means that if I am going to make a loan to you, and I say that I want you to pay, I'm not giving you, making you pay extra money. I'm giving you $5,000. 6 months from now, I want the $5,000 back. Not $5,001, $5,000. I want the $5,000 back. It had to gomer, obviously, Kevin. I'm just paying you principal. I'm loaning you principal for a return of the principal. But what if I say to you, I'm not charging you extra for keeping it for 6 months, but if you keep it one more second beyond the 6 months, you're stealing it from me because you're supposed to pay it back from me. So if you go one more moment beyond the 6 months, I'm going to charge you a penalty. So is that considered to be ribbis or not? So sugya thinking about Basra indicates it's not really considered to be ribbis. If I escrow funds and indicate like I paid you, half of the loan, and now I say, okay, instead of leave the promissory note with a third party, if I don't pay you by a certain date, so then you're allowed to take the promissory note back, and you could charge me the full amount that it says in the promissory note, even though I'll be paying a time and a half more, or an amount and a half more than what it is that I had borrowed. So the Gemara only indicates that it might be an asmachta problem. Okay, it's an asmachta problem, but doesn't indicate that it's a ribbis problem. So the Rimigash says that's because it's a penalty payment. I'm not, nobody here is saying that they're allowing me to pay late, and as a result of charging me more money, the lender wants to collect right away, but there's a penalty if I don't collect right away. So then either I initiate the conversation, I'll pay a penalty, or the lender asks to collect a penalty. That's heter gomer. Says the Rashba, yeah. But you know what? If we're going to allow people to do that, everyone's going to do it when they really want to charge ribbis, and they'll just pretend that it's a penalty payment when it's really ribbis, and therefore it's haramis ribbis. Haramis ribbis is the lightest form of ribbis. Ribbis d'oraisa is Yosef b'diyonim. Ribbis midrabanan, so Yechayev lotzis yidei shemayim. Ribbis, haramis ribbis, nothing. If it was collected, so there's no even chiyuv lotzis yidei shemayim for the malva to pay it back, but it's not supposed to collect in the first place. This is called haramis ribbis, a case of a penalty payment. Says the Rashba, it's also for that reason. But because it's just a haramis ribbis, we're worried that you're going to maybe fool around with this heter, but it's really, strictly speaking, mutter, we're going to allow it with respect to ribbis drabanan. It's what the Shach says in Siman Kupai and Zayin Sipkot and Lamaches. The Shach says if it will be a mecha transaction, you sell something to me or you rent something to me. You're renting your real property to me, okay? And you say if you pay on time the lease by the end of the month, so it's $1,000. If you pay late, it's a $200 penalty, $1,200. So assuming you get out of the asmachta problem for one way or another, that is not going to be a problem of ribbis if it's not in the form of a loaner transaction. So you could say that maybe if I'm dealing with, however, this is only true in, let's say it be a halva type of case. So we say it's considered to be haramis ribbis in the event that there was a one-time penalty. But as I mentioned earlier, if the penalty is not just a one-time penalty, but it is a compounded penalty, that if you pay 1 day late, so there's a $100 fee, and if you pay 30 days late, so that it's a $200 fee, and you pay 3 months late, so it's a $300 fee. So then the Shulchan Aruch indicates that that's a more severe prohibition of ribbis, and that is something that would be prohibited even if I had a mecher transaction. Even that would be prohibited. Why? Because maybe that's considered to be ribbis d'oraisa. It only ribbis d'oraisa. The Shach brings 2 days, but the Shach brings 2 days as to whether that's ribbis d'oraisa with respect to a halva case. Maybe in a halva case it's ribbis d'oraisa, but in a mecher case it's only ribbis d'rabanan. So I'm not. I think that's questionable. As I said, the Shulchan Aruch holds that whenever you're going to specify that individual amounts have to be paid every 30 days or so that's always considered to be ribbis. That's the Sifkat and Mem Zayin and Shulchan Aruch Hilchos Ribbis. Says that's always going to be considered to be ribbis d'oraisa, even in a mecha context. But remember, the Shulchan Aruch held that even if I have a heter iska, which we haven't gotten around to, and we only have 13 minutes, but even if we had a heter iska type of setup, he holds that if you mention the heter iska, that the loba is obligated to pay, the mekabel hamos, the one who's the recipient of the funds, that he's obligated to pay the presumed profits every 30 days or so, this amount, that amount, that amount. It's not just a one-time payment. So the Shulchan Aruch Harav holds that you're not even allowed to do that in a heter iska. Because he'll say, whatever you have, like scheduled payments, this payment, that payment, the other payment, that's more than what the original principle was. So it's always going to be a ribbis issue. But we don't hold that way. So I don't know necessarily in a mechel transaction that we would say that that's ribbis stories. We say in a mechel transaction, even though we wouldn't allow, even though we do normally allow a one-time penalty payment, but we don't allow if it's going to be a compounded payment or a payment that has to be made every single month. We don't allow it if it's we only allow a one-time penalty fee. But would it be that it's so because it's more severe. So, but it's more severe because in the case of a regular hava, that would be ribbis deraisa. So we don't allow that in the case of a mecha because you only allow something that would be a haramis ribbis in the case of hava. That we will allow in the case of a mecha. Something that would be ribbis deraisa in the case of hava. So hava, we're not going to allow in the case of mecha. But maybe it's still deep down in ribbis derabanan. This is important in terms of what type of a lease clause is Yeshiva University, assuming that it's a stock institution. What type of a lease clause is Yeshiva University allowed to have if they're going to rent out property? Are they only allowed to have a lease clause that says that if you pay late, you have to pay a one-time penalty, which everybody's allowed to do? Or would they be allowed even to have a lease clause that says that if you pay late, so then every 30 days, you're going to have to be obligated to pay more for any particular late payment? So if it's different late payments, so a one-time penalty for each different late payment is fine. But if it's a one-time, but if you didn't pay January rent, they're charging you an extra amount in January, more in February, more in March, every single month that you didn't make that particular payment. So we wouldn't allow that with respect to a normal landlord, but maybe a tzedakah institution, if in fact that would really only be ribbis drabanan, maybe that should be mutter. So I think a compromise. What might compromise be? So Shlomo Zalman Auerbach in the same tshuva that I mentioned in the Mincha Shlomo, so chelik beis tinyana. So he says that in his opinion, he's talking about gamachim. He's talking gamachim that if you have a gamach, it's clearly a stock institution where the knas is the fee erach hazman. You pay 1 shekel if you're a half a year late. And if you're a year late, you pay 2 shkolim. So he says, so many say that this is going to be like ribbis. It's not considered to be a knas. So he says he doesn't think so, because that's only if the landlord says, it's okay, I don't mind if you pay late. If you pay late, just you have to pay me extra. But here, that's not what the Gamach is saying. Gamach is saying we have the right to collect at any time. Just that if you're not paying, so we're going to raise and increase the amount of the penalty for every single additional unit of time that you're going to be paying late. So certainly, if it's, let's say, the same amount, that it's just that they say if you're 30 days late, so we're going to charge a $20 penalty. If you're 60 days late, so then the penalty becomes $40. But at any moment in time, the person is obligated to pay. They're not being given the dispensation that they can that they have the right to extend the time of payment. So he says that under those circumstances, he thinks that it would be mutter. So maybe, since Shlomo Zalman holds that this is no worse than a one-time penalty, and a one-time penalty is certainly mutter even if you're not at stock institution when it comes to rent. So only if you are at stock institution, it seems to me that if it's structured in that way, that it's not compounded, where the contract says if you for every single that you have to pay a late fee, and then that late fee is going to be compounded 5% a year for the duration of the amount of the time that you don't pay. You don't make it a percentage, but you just say that it's a certain amount that you have to pay every single month, like the case that Shlomo Zalman has, that it's a set amount that you're paying every single month. If you compound it, you say we're going to give a certain interest rate. So the interest rate already sounds like it's an interest transaction. Like that sounds a little bit more like you're saying, okay, pay whenever you want, but you're going to have to pay a certain interest rate. But you're just saying I'm raising the penalty. The penalty would be this for 1 month, be that for 2 months, and that for 3 months. So it seems to me that if that's the way that the structured penalty payments are set up, that there's a room, potentially more room to be made in that particular context. Okay, that's right. And I think that that's what we have over here. You look at the sample lease clauses that I have. Any payment is overdue for a period of excess in 10 days. The late charge is 5 cents for every dollar so overdue for each month, a fraction of each month from such payment's due date until payment is received by the building owner. So if you translate into English, that's basically what it's saying. Okay, good. And now, next, a very important principle. is the principle of that Ribbis Dvarim. Ribbis Dvarim. So you might think that you're not allowed to collect for Ribbis. You can't collect money. You can't collect items. Like I can't loan you 10 potatoes and say you're going to pay me back 11 potatoes. You'll say, that already sounds like a commercial transaction. It's not Ribbis above me lovel amal. It is. Doesn't matter whether you're borrowing money, kesef, whether you're borrowing ochel. That also is a Ribbis transaction. One of the writers that I quoted, I won't give you which name. One of the writers that I quoted in terms of the wonderful story that have been written in Hilchos Ribbis has a footnote in which he says that if you make a condition, person's borrowing 10 potatoes from me, and he agrees he's going to pay me 11 potatoes, and at the time that he pays the 11 potatoes, it's worth no more than what 10 potatoes were originally worth. So then there's no Ribbis problem. So I beg to differ. I think not only is there a Ribbis problem, but it's actually a Ribbis deraisa problem. But it's okay. You write a whole book on the subject. You're bound to make one typo here or there. So there is one book that says that, and I think he's mistaken. I think he's mistaken. I think that if you charge 11 potatoes for 10 potatoes, it doesn't matter if at the time that you pay the 11 potatoes, it's worth it the same amount that the 10 potatoes were originally worth. I think it's actually Ribbis deraisa. So that's neshech ochel. But then you have neshech kol davar asher yishach. Then you have kol davar asher yishach. Very often when the Gemara talks about davar, it means devarim in terms of things that are going to be said. There's a whole literature, a very fascinating literature with respect to when you make a loan, is the person allowed to say thank you? So it was originally, it seemed like a little bit between a machlokes between Shlomo Zalman and the Mincha Shlomo, where he said that's not a question of that you're giving something extra to the malveh. You say thank you because you don't want to be a kafui tov. So not to be a kafui tov is something that's applicable whatever you're going to do in life. It's not specifically relevant to the fact that this person has done a tova to you, the malveh, by extending a loan to you. So he thought that should be perfectly okay to say yashikoyach. Say yashikoyach, thank you. That sort of thing would be perfectly fine. And Rav Moshe said, no, you're not allowed to say thank you. However, you are allowed, and you're not allowed to give the person a bracha, but you're allowed to say the min hashemayim tivarach, that the person's going to get a bracha min hashemayim. So you write a sefer, the person loans some money, and you put in the sefer, this person will get a bracha. This person will get a bracha. Now, I'm not giving the bracha. Kadosh Baruch Hu is giving the bracha. Rabbi Yosef didn't like that, but that's what Rav Moshe said. Rav Moshe had that particular heter. But the whole big thing about the thank you. So I love the way that it's presented. I think that the Bris Pinchas, the Pinchas Win, presents it very, very nicely. He presents it very, very nicely. I think I've heard the same thing from Rabbi Willig, but I just like the way that he presents this. So I'll read this. He says, let's say that a person, he says thank you. Misha shigras l'shono hiloma b'chol pam todarabba. Person always says thank you. You slap him in the face, says, oh, thank you very much. I'll see you tomorrow. It just comes out of your mouth, everything. He always says thank you. Yashikoyach. He's not even paying attention. He's saying thank you. That's just like, normal conversation. So he says, Ein mamirasan is a Ribbis. Notwithstanding, that was for Moshe Shed. And Shlomo Zalman Auerbach, although he was Mekel in his first tshuva, so in his second tshuva in Chelik Beis, he was actually machmir because he said, oh, I saw in the Shulchan Aruch Harab that the Shulchan Aruch Harab says that you're not allowed to give any kind of hoda'ah. So therefore, he says basically, Hadbibi, that he said even when he wrote his original tshuva, he wrote in the margins that he changed his mind based on what was written in the Shulchan Aruch Harab, and therefore he says that you're not allowed to say thank you. And he says that whoever was matpis, my original tshuvos, that didn't pay attention to what I wrote in the margins, and it was unfortunate. But he says that I think that word, the shmua, has gone around, so people know about it by now. So I don't know. I didn't know about it, but then I saw everybody's quoting it, so I looked it up, and sure enough, that's what he says. But nonetheless, I think that the minhag is like the Bris Pinchas says, and he says like this. This is really a beautiful way of doing it. And he says, you ask, let's say you would ask your friend to borrow a jar of oil. He doesn't have. What would I say to the neighbor? I would say, oh, thank you very much. Thank you very much anyway. Because that's just like what I would say. Kol tu shalom. You say, Toda Rabba kol tu shalom, because that's what I say to everybody. They bump into me. I say, oh, Toda Rabba kol tu shalom. Like saying like buha. And now he goes to the next neighbor, and this neighbor does give him the bakbuk shemen. He can say the same thing. because these are just like the automatic words that he says to everyone. They give him, they don't give him. He's not saying it because of the haba. So if the person would say the same things about, so he thinks that would be perfectly permissible. But you could say, why is this considered to be such an issue per se, that the Torah tells us that even Ribbis Devarim, that even just adding some words of flattery, praise, or whatever to the individual is going to be a problem of Ribbis. So I think you have to say that the Torah is yored, the self-daito shaladam, that when, even if it's a wording that you would say that you wouldn't have otherwise said to the person in the past, that exhibits a certain feeling of indebtedness. And one thing that the Torah did not want us to have, and that's why the Torah says you can't, give money to somebody and say, oh, do me a favor and find out, when this person is coming to town for me. Why? You wouldn't normally charge money to go and ask, like, to look at your watch and see what time it is, or to find out when somebody is coming to town. So why is it that in the context of Ribbis, this is a problem? So the poskim will explain, because the idea is that the Malva is causing the lover to be nichna. He's causing him to feel like the sense of subjugation towards him. This is what the Torah doesn't want. Torah does not want this sense of sort of a feeling of an unequal playing field because of the fact that somebody has to borrow money from somebody else. And even if you think that it is not really an indication of that, nonetheless, it's like the Chazon Ish says with respect to shokha, that the littlest type of item can have somebody who is like the paradigm of integrity, who takes something from an individual who's a Baal Din and wouldn't think that this should affect his judgment at all. The Torah tells you that whether the person is normally affected or not, they are going to be affected. The Torah is telling us that there is going to be some sort of a feeling of hachana if the lover is going to say some words that they would not otherwise have said to the malva, if not for the fact that he's extending a loan to him, and therefore, I think that's kind of the message that is being conveyed with respect to this particular halacha, sort of the hashkafic message that the Torah is conveying. We're now at 3:00, and I had 4 other areas that I wanted to cover, but Yemez Hashem, next time, od chazon moed. And everyone should have a lot of hatzlacha going to help us Ribbis this year. It's a very geshmak alima.